Associate Justices of the Supreme Court of the United States are the members of the Supreme Court of the United States other than the Chief Justice of the United States. The number of Associate Justices is determined by the United States Congress and is currently set at 8 by the Judiciary Act of 1869. Associate Justices, like the Chief Justice, are nominated by the President of the United States and are confirmed by the United States Senate by majority vote. This is provided for in Article 2 of the Constitution, which states that the President shall nominate, and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. Article 3 of the Constitution specifies that associate justices, and all other United States federal judges shall hold their offices during good behavior. This language means that the appointments are effectively for life, ending only when a justice dies in office, retires, or is removed from office following impeachment by the House of Representatives and conviction by the Senate. Each of the justices of the Supreme Court has a single vote in deciding the case is argued before it. The Chief Justice's vote counts no more than that of any other justice. However, in drafting opinions, the Chief Justice enjoys additional influence in case disposition if in the majority through his power to assign who writes the opinion. Otherwise, the senior justice in the majority assigns the writing of a decision. Furthermore, the Chief Justice leads the discussion of the case among the justices. The Chief Justice has certain administrative responsibilities that the other justices do not and is paid slightly more. Associate Justices have seniority by order of appointment, although the Chief Justice is always considered to be the most senior. If two justices are appointed on the same day, the older is designated the senior justice of the two. Currently, the senior associate justice is Antonin Scalia. By tradition, when the justices are in conference deliberating the outcome of cases before the court, the justices state their views in order of seniority. If there is a knock at their conference room door, the junior justice must answer it. The current junior justice is Elena Kagan. Under 28 U.S.C. 3, when the Chief Justice is unable to discharge his functions, or that office is vacant, his duties are carried out by the most senior associate justice until the disability or the vacancy ends. The current associate justices are retired associate justices. When justices retire, they have the opportunity to assume duties similar to the senior status assumed by district and circuit judges. This means that the justice keeps his or her title, and may serve by assignment on panels of the U.S. Courts of Appeals, or even the U.S. District Courts if so requested and assigned. Retired justices may choose to keep a set of chambers in the Supreme Court building, as well as to employ law clerks. The names of retired associate justices continue to appear alongside those of the active justices of the court on the bound volumes of Supreme Court decisions. However, retired associate justices take no part in the consideration or decision of any cases before their former court, although they may be appointed by the Chief Justice to sit on lower courts. Currently, there are 3 retired associate justices: Sandra Day O'Connor, who retired on January 31, 2006, David H. Souter, who retired on June 29, 2009, and John Paul Stevens, who retired on June 29, 2010. Both O'Connor and Souter occasionally serve on panels of the Courts of Appeals of various circuits. As of present, Stevens has chosen not to so serve. List of Associate Justices, also appointed 1 Chief Justice. Also appointed 3 Chief Justices. See also, Associate Justice, Demographics of the Supreme Court of the United States, List of Justices of the Supreme Court of the United States, List of Justices of the Supreme Court of the United States by court composition, List of Justices of the Supreme Court of the United States by seat, references, ABCDEFGH. Recess appointments are a notable exception. See U.S. v. Woodley 751 F2D 1008, 10014. Recess appointments to the Supreme Court are exceptionally rare. Only 2 Chief Justices and 6 Associate Justices have received recess appointments, and only John Rutledge was not subsequently confirmed by the Senate. The last president to make a recess appointment to the Supreme Court was Dwight D. Eisenhower. Barnes, Robert. Supreme Court Chief Justice Roberts opts not to ask Congress to raise judicial salaries. The Washington Post. Retrieved February 17, 2010. Further reading, Abraham, Henry J. Justices and Presidents, A Political History of Appointments to the Supreme Court. New York, Oxford University Press. ISBN A0-19-506557-3. Christensen, George A. Here Lies the Supreme Court, Graver Sites of the Justices, Yearbook. Supreme Court Historical Society. Christensen, George A., Here Lies the Supreme Court, Revisited, Journal of Supreme Court History, Volume 33 Issue 1, pages 17-41, University of Alabama. Cushman, Claire. The Supreme Court Justices, Illustrated Biographies, 1789-1995. ISBN A1-56802-126-7. Frank, John P. Friedman, Leon. Israel, Fred L., eds. The Justices of the United States Supreme Court, Their Lives and Major Opinions. Chelsea House Publishers. ISBN A0-7910-1377-4. Hall, Kermit L., ed. The Oxford Companion to the Supreme Court of the United States. New York, Oxford University Press. ISBN A0-19-505835-6. Martin, Fenton S. Goyette, Robert U. The U.S. Supreme Court, A Bibliography. Washington, D.C. Congressional Quarterly Books. ISBN A0-87187-554-3. Toobin, Jeffrey. The 9. Inside the Secret World of the Supreme Court, New York, Anchor Books. ISBN A978-1-4000-9679-4. Urofsky, Melvin I. The Supreme Court Justices, A Biographical Dictionary. New York, Garland Publishing. PA 590. ISBN A0-8153-1176-1. External links, Historic Collection of Supreme Court Decisions and Biographies indexed by judge name, members of the Supreme Court of the United States from the court's website.